Hi, everyone, and thank you for joining today's webinar, Conducting Effective and Lawful Investigations. As you know, workplace investigations can be a daunting task. It's critical to maintain objectivity, uncover important facts, and maybe most importantly, follow compliance and confidentiality procedures. Before getting further into today's topic, I would like to take a moment to introduce myself and my organization, ComplianceHR. My name is Stephanie Zielinski, and I'm the Marketing Director for ComplianceHR. You may recognize my name because I'm the point of contact for the Littler and ComplianceHR joint events. So, my contact information is in your email from the invitation if you have any follow-up questions for this event. But to prevent a few from trickling into the Q&A box today, yes, this presentation will be recorded and it will be sent to you via email from ComplianceHR. It will also be in your Beacon Live webinar account. Now, a bit about ComplianceHR for anyone unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler Mendelson. ComplianceHR delivers expert employment law guidance in a fraction of the time. Our goal is to simplify the complexity of employment law, something that we'll learn a lot about during this presentation. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics like employee overtime, independent contractor classification, onboarding and leave documents, wage and hour information, and the solution that I'll be focusing on today, handbooks. Keeping an updated and compliant employee handbook is essential because it's the backbone of company culture, employee standards, critical compliance policies, organizational procedures, and, as I'm sure we'll touch on today, other items like safety procedures. Get a jump start on compiling this incredibly robust content with PolicySmart. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliance templates, a compliance timeline, handbook checklists, and even automated emails to alert you on new legal changes. Once you select your jurisdiction-specific content, you can even export it into an easy-to-edit Word document to add branding and other cultural initiatives. If you're interested in learning more, a survey will pop up on your screen. Simply answer yes, and I will send your contact information to our team of experts to have a deeper conversation with you about your compliance strategy and how we can support it. If the poll didn't pop up, you may need to exit the full screen mode to interact with it. In addition to a demonstration of our solution, you'll receive a 1-week free trial of our products so that you can see precisely how much time and money we can save you. If you're not sure at this time, I'll likely ask again before we conclude the presentation, but you can always request more information via the link on the side panel or in the Q&A box. All right, so I'm going to go ahead and close that poll and move on to introducing today's presenter. I have the pleasure of announcing today that your presentation will be conducted by Rocio Blanco Garcia. Excuse me, Rocio. Rocio is a shareholder at the Littler office in Miami. She counsels and represents clients in a broad range of labor and employment matters, including employee handbooks, the employee life cycle from hiring through termination, and conducting investigations and preventing discrimination. Rocio, I will pass it over to you for today's presentation.
Thank you, Stephanie. Hi, everyone. Thank you so much for being here today and for being part of this important discussion that we are about to embark on. I am fairly conversational with my presentation style, so please do not worry if you don't hear me say everything that's on any given slide. That's because I think that this should be a conversation and interaction, and that you should, in a way, have the opportunity to direct where we go next through your questions that I hope to be able to answer live as we go on with the presentation. There are many of you participating today, so of course, if there are any questions that I'm not able to answer, do not worry. I'll do my best to answer them after the presentation and to make sure that we get you everything that you might need. But, without further ado, let's talk about why do we do investigations? Well, investigations are essential to a healthy workplace. What do I mean by that? Well, they're not just essential because the law tells us that we ought to investigate certain things, but also because it helps us build the culture. It helps us build fairness and trust. Imagine that you have an employee that comes to you, that goes to HR and complains about something that they feel was done wrong or that they're uncomfortable about, and that we just brush them off, dismiss them, and do not do anything with that. That is not going to be a happy employee. That is not going to be an employee that's going to feel invested in our company, that's going to trust us, that's going to think that we are fair and equitable. Um, so it is important that we investigate concerns that come to us. It is important also because it builds teamwork and accountability. If we are not investigating allegations, how can we hold our leaders accountable? As I stated, it reinforces morale and pride. You want to work for a company that takes pride in ensuring that we are following the law, that we're being ethical, that we are complying with what's required of us. And of course, it mitigates financial and legal risk. If somebody comes to you and complains and we do not do anything about it, we may be violating applicable laws. That may be a failure to investigate that the Equal Employment Opportunity Commission may ding the company for. So there are a multitude of reasons why we must conduct investigations. And today we're going to talk about how do we go about doing that? What are pitfalls that we should be avoiding? But before we get into pitfalls, let's talk about the role as an investigator. Now, some of you who are joining us today may act on that role of investigator, or you may serve as counsel to an investigator, or you may be a partner to an investigator. Nonetheless, this information is crucial to you so that you can either apply it in your day-to-day role as an investigator or so that you can share it with those people that you're partnering with. Now, as an investigator, it is very important that we leave behind our biases. We have to go into this investigation as if it were a clean slate. We have no preconceived notions of who's right and who's wrong. We don't go into our investigation thinking, oh, here we go again, Rocio, the troublemaker, here she goes complaining again, because that already makes us feel that the complaint may not be legitimate. And therefore, it it inserts a bias in a place where there's no room for bias. So it's important that we go in with our biases, that we be a good listener. We are listening to understand, we're listening to document. So we want to make sure that we go into this investigation paying attention that is everything that is being said so that we can follow the appropriate leads and hopefully reach the appropriate conclusion. We want to be thorough in our investigation without going into like rabbit holes and just, endless investigation that may not serve a valid purpose, but we want to be detailed and thorough. We want to reach reasonable conclusions. We want to properly document investigation. I always say that in this employment world, we have a few best friends, our lawyer, HR, and documents. So many times employers tell me, oh yeah, we looked into that, but we didn't like document it, or we kept it informal. No, put it on paper, document, do your due diligence so that if we ever need to refer back to those documents, we have them and we do not need to speculate and we do not need to engage in he said, she said. And your role as an investigator or as a partner to an investigator is also, as appropriate, to recommend the appropriate remedy. Was the complaint substantiated? And if so, what is going to be the appropriate discipline? Now, I mentioned pitfalls in the investigation process, and the first and most obvious pitfall is not conducting an investigation. It goes back to the hypothetical I gave you of an employee who comes to you and tells you, like, hey, I feel I'm being discriminated against, or I feel that the environment here at work is a little toxic, and we just brush it off and do nothing. That is a major pitfall. Obviously, we cannot do that. We need to investigate complaints. How do we determine when to investigate? Well, Even if the complainant tells you, hey, I don't want anyone to get fired or in trouble, that doesn't mean we do not investigate. If the complainant comes to you and tells you, like, hey, I have this concern, but I don't want to make a thing of it. I don't want you to look into it. I just wanted you to make you aware. I just wanted to make you aware. We still investigate. If you ask about witnesses and the complainant declines to offer names, you still investigate. You investigate based on the information that you have. And then, you may document as part of your investigative process that the complainant was not willing to provide names of witnesses. And that may ultimately impact the outcome of the investigation, that may ultimately impact the conclusions, but we still investigate. If the complainant tells you that he or she is afraid of retaliation and doesn't want to go any further, we still investigate and we reassure that complainant of our policies concerning anti-retaliation. We should all have in our handbooks policies that talk about how it is of an unfair or unlawful employment practice and how we will not retaliate against employees who do so. So as part of the investigation process, and I'll get into more detail on this particular topic in a few minutes, we will reassure our witnesses, we will reassure the complainant of the anti-retaliation policies, but even if they are afraid of retaliation, we still investigate. And even if the person who is accused of the misconduct is a high performer or other influential person within the organization, we still investigate. Just because they're complaining about our CEO, that doesn't mean we just brush it off and we don't dig in. We investigate. We always investigate. EEO allegations, so that means equal employment opportunity allegations, and that's going to include allegations of race discrimination, gender discrimination, national origin discrimination, etc. We're also always going to investigate significant violations of policy. So let's say that the company has a code of ethics that prohibits certain dealings or interactions with third parties, and there has been a violation of that policy. We are going to investigate that. We are going to always investigate potentially unlawful practices or things that may lead to liability. And we are always going to investigate things that may create potential risk for the company or other employees. So a safety violation, for example, that will be something that we should investigate as well. When in doubt, investigate. And also when in doubt, partner with your in-house counsel, with your outside counsel to determine what should be the breadth of the investigation. Now, here are some hypotheticals. What if the complaint comes to you in the form of a resignation letter? I, Rocio Blanco, I am quitting my job at so-and-so corporation, and in my resignation letter, I write something to the effect of, after enduring months of harassment, I have decided that I can no longer be a member of the company, and I am resigning effective immediately. Well, that's a very blunt, direct statement. Sometimes the resignation letter may not be as direct of that. But if the complaint is included in an associate's resignation letter, you're also going to want to investigate, even though that person is departing the company. Because if there's an allegation of a hostile work environment or harassment, we are still going to want to look into those things in order to mitigate risk and to eliminate potentially risk for those employees who still remain with the company. So if I have been abused in my work environment, just because I'm leaving, that doesn't mean that the abuser does not remain in the company and is still posing a risk to the company. So we are going to want to read our resignation letters for clues of whether there is something that we should be looking into. 9 out of 10 times, a person who's resigning typically does not voice any concerns to that effect. But if a concern like that is voiced, we should look into it. What if the complaint includes the same allegations that were previously investigated? Well, even though we have already investigated it, we are probably going to have to look into whether further investigation is required. Why is this issue resurfacing? Why is the allegation being made again? We are going to want to close the loop to make sure that there is nothing new to it. And maybe the conclusion might be the same as it was previously, but maybe not. So we cannot just dismiss the complaint outright simply because it is something that has already been alleged in the past, and perhaps we haven't found anything in the past. What if the complaint is about how HR or management handled an investigation on a prior complaint? Well, in situations like this, if the complaint is against HR itself, sometimes we may need to partner with an outside entity to investigate, because what did I say at the very beginning of this presentation? We need to be impartial. We need to be not biased, right? Unbiased. So, because we need to be all of these things, if the complaint is against our own department, our own HR, our own legal, our own management, sometimes we might need to partner with an outside entity. Other times, we may have another branch of the corporation conduct that investigation, but you still have to investigate. Now, what about anonymous reports or complaints that offer little factual detail? So oftentimes, and we see this a lot in the context of hotline complaints, right? So a lot of entities, particularly larger companies, have a hotline people submit complaints to. And when people submit that complaint, oftentimes they do so anonymously. We are still going to want to investigate within, the extent that we can't. A lot of times, if the employee does not want to identify themselves, that may create some complications, because our fact finding and the fact gathering process will be somewhat interfered with and limited, but we still will try to investigate to the extent that we can. I see a couple of questions. So let me address a couple of this before we move on to the next pitfall. Well, one person asks, when should the in-house legal conduct an investigation, and when should ER? Any advice of when in-house legal team members conduct investigation? So that is a little bit of a business call. One thing I'll say is, if legal is involved, likely a lot of the documents arising from that investigation will be protected by work product and potentially attorney-client privilege. So we typically try to not get legal involved in just about every investigation. We reserve legal for higher level C-suite, or things that pose serious risk to the company. We, as a matter of course, do not have legal involved in just any investigation, right? So we want to be judicious about it because of the protections that come with having your legal department be involved in the investigation. And also, like, think down the line, if there is litigation, do you want your legal department to be a witness? Like, these are all considerations that you're going to have to keep in mind. So we can, talk more offline, but generally speaking, we will just have certain types of complaints or certain types of wrongdoers that get investigated by legal, and otherwise we will leave it to the HR department. All right. Do you recommend contacting an anonymous reporter if you think you know who they are? My assumption is no, because this will hurt the anonymous process. Thoughts? So I'm gonna give you the lawyer answer. It depends, right? Like, we do not have a straight answer for all things. However, typically speaking, you would just go with information that you have, and you could encourage the person to come forward. If you would like to meet with HR, we may be able to gather additional information through a one-on-one meeting, and that those things may encourage the person to come forward, but I wouldn't push the issue if the person does not feel comfortable coming forward. All right, pitfall number 2, failure to understand the scope. So this is, think of it like when you were taking an exam, whether it's in law school or in your bachelor's, any other school setting, or you're taking a test. What is the question what's the issue that's being presented? It is important that we focus our investigation into the actual issue that's coming to us, because if we expand the scope too much, we're going to go down rabbit holes, we're going to waste resources, it's going to waste time. And if we are too limited, we might not get to the actual root of the problem. So in the early stages of an investigation process, one of the things that we are going to want to do is, okay, well, this is the allegation that has come forward. What this is going to be the scope of our investigation, and then we're going to maintain some degree of flexibility, because as you start interviewing witnesses, as you start interviewing the complainant, you may learn other information that will expand the scope of the investigation. So it is important to be focused, but not so focused that you're wedded to that initial scope and do not give yourself room or the possibility for expansion. So be flexible, but also be focused in your investigation. Documenting the allegations. I mentioned this at the beginning, that it is very important that we maintain documentation as we are investigating the complaint that has come to us. And it is important that we be mindful, purposeful, deliberate with the language that we're using when we're documenting these allegations. We want to use objective language. And we want our notes and our analysis, our fact finding, to be grouped together in a logical way. We do not want to use legal conclusions, and we do not want to put words in the complainant's mouth. So, for example, if I come forward with a complaint, the expectation will be that HR say, Rocio relayed that on such and such date, she encountered this issue with a manager, and she communicated that caused her to be upset because of XYZ. That would be objective language. Subjective language would be, Rocio is being highly emotional and showing weakness in her, or showing an inability to present facts without crying or something like that, right? That could be subjective, and that can taint the outcome of the investigation. So objective language is a must. And do not use legal conclusions, because you're not concluding anything yet. You're just fact finding at this point. Pitfall number 3, failure to develop an investigation plan. So just a minute ago, I told you to be focused but flexible in the scope of the presentation. And the same goes with your investigation plan. You're going to want to prep, right, before you go in there and start asking questions. You don't want to jump in a pool without knowing how to swim. The same is true for an investigation. You don't want to jump in and start asking questions without having had a chance to really think through the scope and develop an investigation plan. So, and the investigation plan, much like the scope, you have to remain flexible about it, right? So it may evolve as you learn new information. But one of the key things that you're going to want to do earlier on is identify key witnesses and the topics at the start. So when you speak with the complainant, you are going to ask the complainant, well, who are some witnesses who may be able to corroborate? Who are some witnesses who may have witnessed the same thing? Is there anybody else who you think we should talk in connection with this complaint? Because those are going to be the people who are going to give you the facts that you need in order to reach your conclusions. And as you speak with more witnesses, they may give you other witnesses that will then cause you to expand the scope of the investigation and to have to adjust your investigation plan. And once you think you have spoken with everyone who you wanted to speak to, go back to what was your original plan for this investigation. Revisit that plan at the end to confirm that you actually spoke with everyone who you meant to speak with, and that you gather all the information that you were hoping to gather. Because, it may be that now the plan has changed and we no longer need to speak with those people and we no longer need to gather that information, but it may also have been that we forgot a step in our process, right? So that plan will also serve as a post-it note of sorts, as a reminder of what we meant to do early on. Somebody asked, what if an employee is using the word bullying or harassment out of context? Do those buzzwords automatically constitute an investigation? I don't think those buzzwords automatically require an investigation. I think those buzzwords automatically require questioning. So at the very least, if I am in HR and somebody comes to me and says, I feel I'm being bullied, but I'm misusing the term, like that person is misusing the term, in order for me to conclude that that person is misusing the term, I'm probably going to want to ask some questions like, well, why do you say that? What do you mean what do you mean when you say bullied? Can you please give me an example of what you think you are facing? And those clarifying questions then will allow us to determine what our next steps are. But I always describe the employer-employee relationship as a little bit of a marriage. Like communication is key. And a lot of things will just fall into place based on communication. So we're going to be communicating with our employees to determine where we need to go next with a particular complaint or where we need to go next with a particular, statement that has been made. It may be nowhere, but it may be somewhere. So we just need to engage in that back and forth and communicate with our employees. Um, all right, next. So I already touched on this, identify the issues and then select the means by which you're going to get to the bottom of the complaint. That will be gathering documents, that will be speaking with witnesses, and it also may be, other resources like looking at policies or engaging a vendor to gather some information. It's going to be very specific to the particular complaint. Now, when interviewing witnesses, of course, we don't want to ask them just like random thoughts and things. We want to be targeted and, as I said, purposeful with our questioning. So we are going to want to keep in mind what the issues are that are being investigated. And we're going to want to know who has knowledge or was involved with the issues being investigated so that we can go ahead and interview those people. And this is not a witch hunt, but we want to be thorough. We want to be detailed. So that we make sure that we have all the relevant facts before we reach a conclusion. What are some documents that we may be using in the context of an investigation? Well, personnel files, right? We're going to want to look to see if there were prior complaints or if there was prior discipline for misconduct of the same type that's being alleged in this particular situation. We're going to want to look at performance evaluations, time cards may be relevant. For example, if there's an allegation of wage theft, a time card may be relevant. Medical files could be relevant also. For example, if there was the allegation is a breach of confidentiality by a manager. With respect to HIPAA protected activity, for example, we may want to look at medical files for that. Expense files, if there is an allegation of misuse of company funds. And there's a multitude. I cannot list every possible document that you may use in an investigation, but that initial scope, that planning phase, should include an assessment of what documents do we think we need in order to get to the bottom of this. And that may also include electronic data and communications. So maybe we may be looking at instant messages. Nowadays, a lot of companies use internal like messaging, whether it's Teams or some other form of chat function, and some of the alleged misconduct may have occurred through that chat function. So we are going to want to gather that information, partner with our IT department. Social media may be of consequence to the particular investigation. So do not just think physical files, do not just think traditional documents, but also keep in mind that electronic data and electronic communications may be part of the investigation and of the documents that we need to gather. Now, when you are getting ready to, you've determined the scope, you've done your planning, you're ready to start interviewing people. Well, there needs to be an introduction because most people will feel a little put off if they get told, "Hey, come to HR, we want to talk to you." Some of us may think that we're being disciplined or that something is wrong. So we're already you have to think of the psychology of a person, right? Like that person is already walking into the office with some hesitation and trepidation for the process. So our introduction, how we present the process, how we present ourselves is going to be very important and set the tone for what's about to happen. So you're going to want to tell obviously the person who you are interviewing what your name is, what your title is, what your role is with the company, and what your role is as part of the investigation. And you're going to want to give that person a short statement about why the meeting is happening and basically what we are there to do. And you're going to want to explain the process. It is a neutral process, and that the goal of the meeting really is to have an open and candid conversation, so that all these introductory statements are designed to make the interviewee feel comfortable sharing what he or she knows. And I mentioned this earlier, we're going to want to remind them of the non-retaliation policy. As I said, the person is coming into the office with some hesitation, with some trepidation. So we are going to want to make them feel comfortable and help them understand that there are no repercussions for this discussion that we're about to have. We're here asking you questions because we want to find out what happened, and you will not be retaliated against in any way for the information that you are to share. That is a very important part of that introductory conversation with the interviewee, because a lot of people are hesitant to share information just because they think it can come back and hunt them, or because they think they may be retaliated against if they are candid. So this is important. That's the tone for what's about to happen. um Somebody asked, do you have a template for how you document the investigation? I'm sure we probably do, and I can connect with you after if you would like to, get some ideas for how you can do that. Um, there's not a fixed formula. It's more important the substance of the form, but we do have templates that can help you um, guide the investigation. And as long as you remain flexible and not so wedded to the template that you do not see anything else, you should be okay. But definitely that's something I can get you after the presentation as well. All right, failure to vet the bad actor side of the story. So I see this all the time where the company terminates the person because they did conduct an investigation. They, let's say it's an allegation of sexual harassment. Multiple women come forward, their stories match. It really seems like, multiple people feel that so and so has engaging in appropriate behavior by touching or by making sexual comments or jokes or what have you, right? And so we go ahead and we terminate the bad actor, but we do not interview the bad actor, the alleged bad actor first. That's a pitfall. Now, there may be situations where we might not investigate the bad actor, but I would say that those are the exception rather than the norm. Even if we're ultimately going to fire him or her, we should give them an opportunity to express their side of the story. And as I said, I see these a lot of times because then that bad actor will turn around, sue the company for whatever, discrimination, retaliation, what have you. And one of the things that they'll say, it's like, they were out to get me. They never even let me explain my side of the story. They never let me communicate what my response to these serious allegations that were being made against me, right? So even if ultimately it's not going to change the outcome, I think it is important to vet the bad actor's side of the story. So when you're interviewing the bad actor, the accused, you have basically the same goals as with any other witness. It's information gathering. If we are required to conduct a full investigation, as we are, then we should listen to the bad actor side of the story. And it also gives them a fair opportunity to respond. And as human beings, oftentimes that's all we want, a fair opportunity to respond. And that can also serve as a way to mitigate risk and to keep people from um, turning around and suing the company, because they, if you give them a fair opportunity to respond, they won't feel muzzled. They won't feel like they were not heard. And that in and of itself is a mitigation tactic. Now, when you're interviewing the complainant, you're going to want to get as much detailed information from the complainant as possible. If we go back to the question about what if it's an anonymous complainant, well, you might not be able to get as much information as you would from a person who is being opened and coming forward um, to complain. You're going to want to listen impartially without committing yourself. So when you are asking these questions, I don't want you to be thinking, I think she's lying. Like, don't have that in your head. Just instead, you can document, she stated this while she had previously stated this other thing, which was inconsistent with that. That is an objective documentation. But if you write, oh, she appears to be lying, that is not objective. You want to ask open-ended questions, and later on, we're also going to talk about funneling your questions. And the reason why you want to ask open-ended questions is because you're going to gather more information that way. For those on the call who are lawyers, right, we know that when we want to find out more information about something, we will ask open-ended questions, versus when we want to commit a person to a particular thing, we will ask very tailored, otherwise known as leading questions. So these open-ended questions are going to allow for additional fact gathering. And you're going to evaluate the complaint from the complainant's perspective as well. Communication is a key to this marriage, right, between employer and employee. So one of the things that we as human beings want to do is we want to feel heard and seen. So you're going to emphasize that the complaint will be taken seriously. You do not need to be empathetic in saying, I'm so sorry this happened to you. You should not make comments like that, because you do not know what actually happened. That's what you're there for. You're there to investigate. But you do want to let the person know that it will be seriously, and that this is not just rubber stamping or following some process without meaning. You should let the complainant know what you intend to do and also how long something may take. um, Sometimes as the complainant, a week or 2 weeks may pass by and we might be wondering, well, what's going on? Why is nobody getting back to me? But if earlier on we have let the complainant know, like, hey, this is something that we take seriously, we're going to investigate thoroughly, it may take some time, just be patient, that also helps set expectations, and the person won't feel like nothing is being done. To the contrary, their mind hopefully will go to a place of where they're thinking, well, this is taking long because the company is taking seriously. But the communication is going to be key to that. And I mentioned funneling questioning. So you're going to start open-ended, and then as the investigation evolves, you're going to want to ask clarification questions. Something to the tune of, well, earlier on you mentioned, this, and this. What do you mean by that? Is that all you meant by that? That's when you start doing a funnel, right? You start big and then you go small so that you can get to the bottom of it. Somebody asked, what are best practices if we are seeing employees use more buzzwords like harassment or bullying to escalate when the situation is not harassment or bullying? How can we educate our staff on when to use those words? Training, training, training. You need to have a handbook that sets forth policies that explain what is considered harassment, what is considered bullying, what is considered, discrimination. And then a lot of companies will do annual training so that employees understand what those things actually mean. So there is an education component that comes with employer-employer relationship, and I honestly cannot encourage you enough to devote the time and the resources to make sure that you have your policies in writing and that they are well communicated to employees through training, whether that is live training or whether that is webinars or some other certification that they need to go through. Like a lot of employers will have a webinar and then at the end there's like a quiz for employees, and then they have to like complete a certification, and that certification goes into their personal file and serves as a record that they took that training. And also open door policies. Encourage your employees to come to HR with any questions as to what any of these things mean. Okay, I already went through this, so I'm gonna skip ahead a little bit. And make sure that your questions have a purpose, right? That's why that early planning phase is so important, because once you determine the scope and what it is that you are there to do, all your questions should have a purpose, should be written in such a way that you're trying to get to the bottom of what that goal is. All right, pitfall number 5, showing bias. I introduced this concept earlier on during our presentation. You should not investigate your own peers or supervisors. That's why sometimes, depending on against whom the allegation is, companies will have to secure an outside person to conduct the investigation, or if it's a large corporation, another branch of the company may conduct that investigation as well. And not only your actual bias, but also optically. Like sometimes we might not be actually biased, but because of our relationships, it may appear that we are. So I would encourage you to not investigate anything that you have a bias towards, but also anything that might create the perception of bias. You should avoid making judgments during the investigation. Gather all the facts first before you reach any conclusions, because if you make judgments in the investigation, that will taint the process, and it may also lead you to not ask certain questions or to not go some places that you should in the course of the investigation. And of course, be polite and courteous and use discretion during interviews. You want to be reserved in your conduct. I think I alluded to this earlier when I mentioned empathy. Sometimes, an employee may come to us crying, and our instinct may be like, I'm so sorry this is happening to you. That's so wrong. That's so unfair. But we can't be saying those things because we do not know what's happening. We do not know if it is unfair. We do not know if it is wrong. And if we say things like that prematurely, it may come back to bite us, right, later on, because employee will surely say, well, I went to HR and HR agreed with me that it was wrong. So we want to be very reserved in our conduct. Pitfall number 6, losing confidentiality or promising it. So there is a degree of confidentiality that comes with an investigation. So we should not be talking about the investigation freely with everyone, but there are some people who might need to know about the investigation. So it is important when we are investigating something that we do not promise the witnesses that there will be absolute confidentiality. Instead, what we can say is that, this information will be shared only with those who need to know, and we ask you that you please do not share this information so as to not compromise the quality of our investigation. So even sometimes, as HR employment attorneys, sometimes we get very juicy, right? Details and information that will make for great water cooler conversation. That is wholly inappropriate. Even if you've learned the juiciest of juicy details, you should be reserved and keep that confidential, because otherwise you are losing confidentiality. And if we go back to the very beginning of my presentation, we are investigating in part to avoid liability, but also to build trust, to create a culture of fairness, and to have our employees be invested in our workplace. And that will be super detrimental to morale and to everything that we're trying to do if we share details that we shouldn't be sharing. So that is an important thing to keep in mind. Not overpromise confidentiality, but also do not lose confidentiality by sharing with people who do not need to know. Pitfall number 7, allowing retaliation. This should be an obvious one, but the theme that I have mentioned throughout, the last 45 minutes that we have been talking is that it is important to remind employees that they will not be retaliated against, and it is important to educate our managers on what constitutes retaliation. If a manager somehow ends up learning that an employee, that a subordinate has complained about him or her, that manager better have education and training on what they're not allowed to do. They cannot now start giving them the less desirable assignments. So they cannot now start casting them aside and not inviting them to team activities, because that is going to create issues in the workplace. So one thing that I hope you walk away with from here today is that education and investigation sort of go in tandem, right? The more you educate, the more you engage in early mitigation strategies by having your handbooks, by having those training sessions, the less likely you are to have issues in the workplace that then require you to investigate. So it's not, you have to think of this as multiple pieces of a puzzle that have to come together to create the ideal workplace. So as I mentioned, retaliation includes things like being excluded from meetings, reassignment of job duties or department, and reduction in hours or job transfers, for example. Not properly documenting, that would be your pitfall number 8. Take good notes. Take the time to perhaps transcribe them. I mean, I don't know about you, but if I write notes today, tomorrow I won't be able to read this, right? So sometimes while I'm on a call or speaking with a client, I'll take notes, and then I'll go and put them in a Word document as well, so that I'm able to read them, tomorrow in 3 years from today. Because those of us who are familiar with the US legal system, one thing that we all know is that a lawsuit may, things that we do today may be part of a lawsuit 3, 4, 5 years down the line. And so we are going to need to document everything in a way that's going to be legible and useful, not just for our immediate purpose of getting to the bottom of this allegation, but also for the potential subsequent purposes of dealing with litigation. And sometimes you may want to have a witness in the interview. So I have seen some employers, as part of the investigation process, one thing that they'll do is that they'll have the main investigator asking questions, and then they'll have a neutral or an unbiased neutral third person sitting in the room solely for the purposes of taking notes, so as to maintain the legitimacy of the investigation and protect both the interviewer and the interviewee. So I have had that. That's something that some employers do, and it can be very useful. And make sure that you properly maintain separate investigation files. The allegations of misconduct and the ensuing investigation, that's not something that needs to go in the personnel file. The personnel file will include whatever discipline may be issued as a result of the investigation, but the actual investigation file should be kept separate. So again, write objectively. You want to summarize the knowledge that is being, the information that is being relayed to you. You want your notes to give specific responses to key questions in documents. You may use quotes if you are able to, write quickly enough to express what the for key things that the employee may be saying or that a witness may be saying. And you want to use relevant facts regarding credibility. I mentioned this earlier. An objective way to document credibility would be to say, Rocio stated X while she had previously stated Y. that shows an inconsistency in an objective manner. You want to avoid making conclusions as to the facts and credibility. So don't say Rocio is a liar. Say Rocio said X while she had previously said Y. And you do not want to stick unwaveringly to the script. Remember what I said very earlier on. You want to have the scope, but you want to be flexible with it as well. And this is an example. A bad way to document would be Pat excluding Maria based on her gender. That's conclusory. Where a good way to document the same thing may be Maria applied for the upgraded position on such and such day. 4 others applied for that same position. Maria was not offered the position. Maria was informed that she had not received the position. Maria left a voicemail on the company hotline stating the following. Her quote of, I feel I was excluded because of my gender. This is a good way to document. This that we see on the left side is not a good way to document. All right, so a final note about your notes. So if you are keeping, I think it's very important that we do everything with an eye towards what's the worst case scenario. If we have to always be documenting things with an eye towards there may be litigation one day about this. So be careful what you write. Be careful how you write it. Again, I'll encourage you to type them so that they can be understood 2, 3, 4, 5 years down the line. And you want to include things like dates, who's speaking. Do not use passive voice because you will not remember a week from today who were you referring to when you were using passive voice. So you want to say Rocio said instead of it was said that blah blah blah, because you will not know that once memories fade. Pitfall number 9, over documenting. So we have to strike a balance. We do not want to have bare bones documentation that it's basically meaningless, but we also do not want to over document. And I want to direct your attention to the last bullet point. Avoid documenting recommendations. So I see this all the time where the investigator will say, based on my investigation, I recommend that the person be put in a performance improvement plan. And then it goes higher up to HR, and then it goes higher up to legal, and they're like, oh no, this person should be terminated. Well, guess what happens? 2, 3, 4, 5 years down the line, I am litigating the case, there is a discovery request, and we find out, the plaintiff finds out that, so-and-so, the investigator actually thought that they should have been put in a performance improvement plan as opposed to being terminated. You bet that's going to be used against the employer. That is going to be used as evidence that the termination was unwarranted and that perhaps we were out to get this particular employee and that this was all pretext for discrimination, right? So we want to document the facts, then we have our meeting, the minds come together, and we can then decide on where the appropriate discipline is. But documenting recommendations that may then be overturned by others can be detrimental to the company. And so how do you make a decision as to what the appropriate outcome is? Obviously, the credibility of the witnesses is going to be important, and that's going to be ascertained based on the information that they share with us. And how do you determine credibility? Of course, you look for inconsistencies in what they have relayed. You're going to see how many people corroborate one side of the story versus the other. These are all things that are going to help you make that credibility determination. Also, memory, who you want to ask specific questions that allow you to assess how well a person remembers something, because that will determine really how much credence to give to what they're saying. If I don't remember at all, or I was inebriated, for example, there's an allegation of harassment at the holiday party, and I had way too many drinks, well, my memory and the veracity of what I am saying, it's probably not going to be the best. So that may affect the credibility that's given to my statement as part of the investigation process. And corroboration of lack of corroboration is obviously going to be a big one in determining credibility. Whether a person has a bias or not, that's going to obviously be important for credibility. So if I am providing a witness statement about something that happened to my best friend, I may have a bias that influences what I am saying. So that we should be taking into account in determining credibility. Okay. And this I already touched on briefly earlier. So let me add. Okay, we've discussed this before. You do not want your investigation process to be tainted with personal opinions, legal conclusions, gossip, rumors. Be objective, be factual. And you want to make sure that if the complaint is, there are multiple parts to a complaint that comes to you. You want to make sure that you reach a conclusion as to each of the allegations. So sometimes my complaint may involve harassment, discrimination, or sexual harassment, race discrimination, and something else. Well, we're going to want to have a conclusion as to each. We don't want to leave unanswered any of the allegations that were made. Okay. Good. To pitfall number 10. Oops, here we go. Not closing the loop on an investigation. You have done your due diligence, you have your plan, you have your scope, you have interviewed people, you have gathered all of the facts, the documents, you have everything that you need. Well, now we need to close the loop. So you want to advise the complainant of the conclusion of the investigation and preferably do so in writing. We are investigating because somebody came forward with a complaint. And imagine how that complainant will feel if they're never informed of what the outcome was. They might think mistakenly that nothing was ever done, or they might think mistakenly that we didn't take it seriously. So we want to advise the complainant on the conclusion of the investigation. We're going to want to impose discipline as appropriate. So if an allegation was substantiated and there was in fact wrongdoing, we're going to want to partner based on our applicable policies and procedures with HR, legal, as appropriate, in order to come up with what the appropriate discipline should be. And we're going to want to, before we do that, before we impart that discipline, we're going to want to look at how have we treated this type of situation in the past. What have we done before when we had a similar allegation and similar findings? Because uniformity and treating everyone who's similarly situated the same is critical in ensuring that we are best positioned to avoid legal risk. So don't just be handing out discipline without engaging in an analysis of how have we treated this before. If you're new to the company, if you're new to this investigation role, partner with a more senior employee, with a more seasoned employee, and ask, have you encountered this before? And if so, how did you handle it? So that we can make sure that we are being consistent with our application. And of course, consider training. I can say this enough. Communication and education are key to a successful work environment. So we need to, if there is some wrongdoing or the allegation, the investigation revealed that some employees may benefit from coaching on a particular area, we should deliver that training so that we are giving them the tools to succeed and to avoid these issues in the future. All right, that's all I have. Let me try to see if I can answer a few more questions in the 2 minutes that we have left, and then I'll let Stephanie do this. Okay, what does an investigation encompass when a complainant does not want to provide information? Okay, well, I mean, the complainant, you will have become aware of the allegation somehow. So you investigate based on what you have. And you let the complainant know, like, look, I can only help you if you help me. I cannot investigate without knowledge. So there has to be that communication to encourage the complainant to share as much as they possibly can. But ultimately, you are somewhat tied or limited by what you can do based on just the information that you have. So, the answer that I can give you is not a concrete one because it's really just going to depend on how much information is given to allow you to investigate. What should you do if you as HR, if you are told you will terminate if you investigate? Okay, so here I'm understanding the question as saying that HR is basically being told by somebody higher up, do not investigate or else you will be fired. Well, you should escalate that as much as you possibly can, because obviously that's not appropriate. So I would escalate to the extent that you can. And if the person who's telling you this is the highest ranking person within the company, then that could be obviously problematic. But try to escalate to the extent that you can. Oh, is it appropriate for employers to investigate incidents that occur at private events where there are several employees present and involved, such as a wedding? Yes. So the rules do not just apply within the four walls of the workplace. For example, happy hours. A lot of times employees get together for happy hour, they start drinking, then they start making inappropriate jokes. We get a little bit looser with the alcohol, right? And then inappropriate things happen. That is completely outside of the four walls of the workplace, and it is outside of working hours, but we still have to investigate to the extent that impacts the workplace. So yes, it is not limited to the actual building where we work. Stephanie, I think you wanted to do a poll here.
Yeah, absolutely. Thank you so much, Rocio. You did an incredible job today. Everyone, we tried our best to get through the questions. There were over 450. So you guys really provided us with loads of good content for the future. But before concluding today's presentation, once again, I just wanted to offer you the opportunity to register for a demonstration of Compliance HR and receive a complimentary 1-week free trial. So if you are interested, please select yes in the poll that appears on screen, or you can email us at demo@compliancehr.com. Again, you may need to exit full screen mode if you are interested and you wanted to hit that yes button. We are so thankful for all of you guys taking time out of your day to join us. Rocio, did you want to answer any more questions, or should we conclude the presentation?
I'm happy to continue answering for as long as you guys let me, but if we have 400 questions, we might be here until 4 p.m. But let's do a couple more, if that's okay.
Absolutely.
All right, so somebody asked, would you recommend engaging outside counsel for investigating allegations against executives like the CEO, CFO, or CHRO? It depends. We have to look at the principles that we discussed earlier today. Are you going to be able to be unbiased? Are you going to be able to really investigate the issue without being influenced by the powers that be? So that is what's going to determine that. It is common, however, to engage outside counsel for investigations of this nature. One, because of the sensitivity of it. Sometimes we're going to be extra diligent in making sure that we're doing it correctly. And two, because of the concern that we might be biased, or we may fear that we cannot be impartial just because we are investigating a top dog within the organization. So that is definitely something I would recommend under the appropriate set of facts. What if it is via social media without a name? So I assume that this question is going to, what if the allegation or the improper conduct occur over social media and there's no name tied to it? You investigate to the extent that you can. So if somebody comes to you and says, somebody made this comment to me on social media, the name is not there. However, I know that it was so and so. You have enough to investigate, because that's how you became, you've been given enough information to potentially dig in further and hopefully get to the bottom of it. So you work with the information that you have and you do what you can with that. Do you have any recommendations in handling investigations with outside parties like vendors, contractors, or customers? I would say the same rules apply. And this actually brings an important point that I think we should touch on briefly. The rules apply not just to people within the workplace, but also to your vendors and contractors. For example, let's say that you have an employee who comes to you and tells you that, this particular contractor, this particular customer is constantly mistreating them or treating them poorly, or whatever the case might be. Well, you still have, as a company, a responsibility to investigate that and to take appropriate action. So that sometimes may mean that you cannot do business with that particular third-party provider anymore, because you will be incurring liability if you continue to do business with somebody who is mistreating your employees. So I have had situations where a client will have to lodge a complaint against a third-party contractor and speak with higher ups within that organization because the third-party contractor is engaging in misconduct towards the client's employees. So the same rules apply as far as investigations goes, but this brings up that interesting point of sometimes the investigation will involve a vendor or a contractor, and sometimes in order to fulfill our employment obligations, we may need to break ties with those people. For those who resigned and included the complaint in the resignation letter, is it fine that we invite the former employee to return to join the investigation? Yes, I have seen that happen as well. The person is lodging a complaint in the resignation letter. It's totally fine for us to call that person, get in touch, and try to learn more as to why they're saying this so that we can conduct appropriate investigation. All right, I think I need to stop because otherwise I'll keep going and going and going and you all won't be able to eat. But I'll do my best to answer most, if not all of this after hours. And, I'm here for anything that you all need.
Wonderful. You did a great job today, Rocio. And again, thank you everyone for taking time out of your day to attend this presentation. CLE credit and SHRM credit has been sent out, but if you have any questions, you can always email us at cle@littler.com, or you can email me. Again, my email is in your invitation for this presentation. Have a great day.